apologize. I'm not going to, as I say, I can't see everybody on my phone screen, so I'll just extend a general welcome to everybody. The latest edition of these HRUG Open Talks. As you know, the HRUG Open Talks are hosted by the Central South University in Changsha in China. So our thanks to them. We're picking up where we in the series where we left off. I think it was in late April. Or sometime in April was our last open talk, the last talk in this format. So we're hopefully we'll have a regular. This will be a regular meeting time for these open talks. So I will get into the substance of today's talk. The title is Society and Humanity Under Threat, the Value of Law, Expertise and Opinion. And we have, following on from what I think is a fairly regular format that we've been using in these open talks, we have a speaker, a lead speaker, if you like, who will talk for maybe 10 minutes, and then we have two respondents. And today, the lead speaker addressing this topic of society and humanity under threat is Peter Herrmann, amongst his numerous titles, you might say, positions. He's research fellow at the Human Rights Centre in Central South University in Changsha, and we will be having Mehmet, Okyayuz and Juan will introduce later after Peter's talk, but those are the two respondents. But to start off, I will give the floor to Peter Herrmann. Thank you.
Okay, thanks, Joe. Just before Huru was there already, and we talked, and he said it's a very complex, very complicated topic. And I said, yes, in a way it is. At the same time, it is a very simple one. It is about concentrating on what we should concentrate and not being detoured and being caught in details. So the very broad outline is the disappointment of humanity, if you want. By Copernicus, he began this, saying actually our beautiful planet Earth is not the center of everything. And in a way we can say it is actually the invention of planets, meaning there are different planets and they have in a way equal saying. Then was dear Mr. Darwin taking this consciousness of our speciality, of our superiority away. And I found a nice quote, not by him, but by somebody quoting him with this usual thing, do you want to have an ape as grandfather? And this guy said, well, I would prefer actually to have an ape as grandfather, as a human being, well educated, but not being able to grasp reality. So in a way, Darwin saying we are not the superior race. And then you have Mr. Freud making things even worse in a way, saying it's not only that we are not superior, but we are not rational as we claim to be. Now this culminates in a way in digitization, artificial intelligence, and nature claiming some rights, in a positive way, culminating it that we actually found a solution for it. Even if we are not superior, we are able to develop something and control something that is more superior, and that is artificial intelligence, it's digitization, and we are the superior beings as individuals. Now, in law, we find exactly this. It's all about individuals. Social law, in a way, doesn't exist. It's detouring, giving individuals social rights, but there is no social right or even concept of social right as such. Now we have an opposite development, if you want in technical, technological terms. That's the printing press, making things public, saying if we are not superior as individuals, we can manage and communicate in a very controlled way. Then you have the emergence of space. Space in terms of being able, not moving just in the space we have, but calculating or miscalculating, as it happened, space and moving this. That had been about as well Copernicus, Galilei, and others. And it had been about, of course, Columbus. Columbus, there was the miscalculation. He didn't end up where he thought he would end up, but at least he was brave enough to say the Earth is not flat, but we can move around it. Interestingly enough, you have in painting, at the same time, the redevelopment of space, being able to paint space. And I say this because in painting it was as well a development of, if you want, coming out. As individual artist, I managed to work with my arts in space. I explore space. This was not the case before. And this coming out was this kind of, even if I am social, even if I am individual, I'm social individual. This conscious step to say, I am because we are. Now, this is, of course, a tension or even contradiction if you say, or if you relate this to the first developments. So, in brief, we have three, if I didn't miscalculate, three tensions, basic tensions. It's individualization versus socialization. It is the generalization, looking at general laws and specification, specialization. We are looking more and more into details to explore what we lost on the general side, looking at the general universe, universal questions. And then we have the understanding of complex and natural order versus specifically detailed regulated order by law. And this paradox is, as more in all cases, as more as we are able to control details, we lose the entire context, we lose the ability to deal with complexity. I think this is a problem for law today, that we are in exactly this situation where we are able to look at very detailed issues and lose the understanding of what we are actually talking about. Now, one example, very recent example, from another of my neighbors, in a way, the neighboring island, Sylt, where fascists, or at least extreme right-wing people, shouted loudly, Germany, for the Germans only, foreigners leave the countries, symbolizing fascist habits of whatever, the greeting and stuff. Now, there is a general outcry, there is resistance, and many things, similar things happened apparently afterwards. But my point now is, there is this political outcry, but the law looks at two different things. The one is, was it actually, not in political terms, but in legal terms, illegal to do what they did? It's not a political thing. It's just, is there a law that forbids this behavior? And then the next thing is it actually possible, or is it allowed, is it legal to make it public what they did. And some people say, no, it's not. Some people say, actually, some of them lost their jobs. Some people say it's not legal that they are set free, that they are given notice. Now, I am wondering, should we look really at all these detailed legislative processes? Because then you are ending up in a permanent justification in legal terms. No, there is something, and they can do this, they are allowed, it is legal, or the other way around, instead of simply saying there are certain guidelines that we have to observe and that we have to follow. And these guidelines should be actually guideline of legislation, of law, of justice. Now you can say again, if an enterprise gives notice to somebody because of this, this is a matter of the individual protection. But there again, my question would be, is it really an individual case that the enterprise can send a notice to somebody, give notice to somebody, or that somebody claim this is private, what I did there is completely private. It doesn't affect my job. The other version or the other perspective is whatever is private, it is public. Especially in these cases where somebody makes statements as a group or as an individual that is obviously against the community, against the state, against this entirety, against the order, then we should say no, stop. At least we have another problem then, not looking at behavior, but looking at what kind of order is actually justified. So it's another difficulty, but at least we have a question that I think is more concise for today's challenges, including artificial intelligence, if you think about Facebook and the dominance of monopolies, not only controlling the market, but controlling the minds, looking at exploitation of nature. I think we have to refocus our legal thinking as well in such a way that we get the question right. And then we can move on with details instead of looking for more details and the contradictions between details, and then thinking about where there may be something general. So that was it, and I look forward to comments and questions.
Okay, thanks very much, Peter Herrmann, Research Fellow at the Human Rights Center, Central South University, Changsha, sometimes until recently a resident in Berlin also, and now located somewhere next to neo-fascists in Denmark, it appears. So good move. Thank you very much for that very thoughtful and provoking contribution. So as I mentioned,
don't mention it's not only the neighbor of the fascists, but the king as well.
A large agenda to get through today, obviously. So now, as I mentioned at the beginning of this session, we have two respondents, and just in the list I have, in no particular order, I'm going to invite Mehmet Okyayuz from the Middle East Technical University of Ankara to make some comments, say a few words, share some thoughts and observations. Over to you, Mehmet.
Okay, thank you very much. I will make some, in quotes, spontaneous remarks, some of them based on ideas which I developed during my lectures here in China. Peter, as far as I have understood Peter correctly, one of the critique, again in quotes, I know that this is not only a critique in this sense, one of the things he mentioned as a problem was that the legal science, let's say, should not go too much into certain details of trying to analyze social events which are much more complex. And he gave the example of Sylt. I know the example because I follow the German media. I will now give this answer to this. In the 19th century, something historical. In the 19th century, concerning the contextual relation between law and the social context. The latest during this 19th century, the new emerging social sciences, in generally speaking, tried to explore the dynamics of society to find out certain forms of possible generalizations to understand. Because one important thing of theory is generalization and abstract thinking. This attitude was followed and also accompanied somehow by certain wings of legal science, and also legal science based on the diversity of the social relations, political relations, starting with the 19th century, also tried more and more to understand these processes, trying to be the framework conditions of law. But what was lost, and here I will then come to the Sylt thing, what was lost a little bit was that law in this century forgot a little bit that law is nevertheless, even if law has to understand contextualities, has to be special. I say this without being a legal scholar. I accept that law here has a special position because law has to understand like social science, but has at the same time to establish certain norms which are drawn in details. But this exactly happened, I think, because this genuine side of law, which should be restructured, this norm establishing side of legal scholarship and of law, began to be forgotten a little bit, I would say, in a sort of artificial location inside social science. So law has to think contextual without dying inside the details. And I think if we speak of Sylt, there were these party of the well-situated young people in the island Sylt in Germany who spoke out certain slogans linked to fascism. And so I think a lot of legal scholars from which I have listened to the media tried again, not so much to first look to specific, how can we say, formulations and specific criteria, because on the one side, these young people are, of course, not fascists in this sense. But on the other side, the legal scholars tried to bring this social context to the foreground. And by doing this, they mixed up everything. So they mixed up the problem of private event, public event. And I think in this process, this is my opinion about this, how can we say, the right of the individuals to remain anonymous somehow until they get their punishment was violated. So I think law nowadays has the duty, I think, to connect itself again to the context Peter has also written down, the problem that we are not the only creatures on earth having certain rights, etc. Okay, but trying to put these things on the context of historical and social knowledge to the foreground by preserving at the same time this genuity of law. That means law finally makes decisions, and these decisions has to be contextual, but should not articulate itself as if they would be social scientists. So I think the relation, the totality of social science and legal science is necessary, but again, they should not be becoming or mutual attachments of each other. This is, I think, the difficulty. Because social science developed early and law adapted certain methodologies to this by not developing genuinity, I think. And I think this genuine approach of law should be remained. I think law should be preserve this norm setting function, which has been a little bit lost. I think this is some of the problems I have. So interdisciplinarity, okay, but not in the case of attachment. It's like a little bit like mathematics and physics. Physicians say we are more important. The mathematicians say we are more important in general. I know it's more complicated. And then they are becoming more and more some sort of copies of each other without bringing to the foreground genuinities, by at the same time not forgetting they are all in togetherness, not with other branches, with the world and the society itself. And this is the same thing, I think, for the problem of animals, for example, animals protection, world protection, climate change. So the protection of everything which is existent on the earth. So the withdrawal from this anthropocentric view. And this is now the other problem, because as I have read, Peter, a little bit in your text, I developed the understanding that you are in favor a little bit, in a certain extent, to depart from this anthropocentric settings of norm setting. So this is the other problem, I think, which is difficult. We should be debated. How much should we depart from this anthropocentrism? Because anthropocentrism is also more than only an arrogant approach of the human race. It has something to do with social struggle and all these things. Individualism, as we see it nowadays, which is most of the time some sort of egoism concerning the kind of man and also individuals, was of course something different before. Individualism before was a sort of awareness perception, thinking of himself, of ourselves as being valuable, etc. This was the beginning. So I think we should a little bit not reject too much. I know that Peter probably did not meant this, but this should us not lead to depart from certain preferences which came out of these historical contexts and historical struggles and social struggles at the same time. This comes in my mind. The last point I wanted to say is new forms, because, for example, how does law deal with new forms of social activities? For example, civil disobedience, articulating itself sometimes in the context of particular interest. How much should this be integrated or adapted by legal systems? Because law has always two tendencies: to determine from above the structure of the society, or to adapt itself to certain tendencies. So this should also has also a lot of challenges nowadays: artificial intelligence, new forms of civil disobedience, etc. So law has to locate itself very clearly under these paradigms, but also globally seeing there will be problems, because a lot of aspects which Peter spoke about are valid maybe for the so-called Western states, but not so much for other socioeconomic formations. I don't want to say culture, but this is also one point. So this is also the second problem, I think. These are now some ideas I have because I articulated them spontaneously it was maybe not so systematic, but this is my first contribution. Thank you.
Okay, thank you very much. That was Mehmet Okyayuz from the Middle East Technical University in Ankara. Thank you, Mehmet, for those reflections on the relation between law and social science, responding to Peter's views on the Anthropocene and the centrality of the human being or otherwise, and also on civil disobedience. And you remind me that I should have reminded attendees that there's an accompanying text which was circulated in France, a relatively brief but nonetheless dense text, if I may put it that way, that was circulated by Peter. Thank you very much. On the obviously with the title of the presentation, and yeah, kind of dense and wide ranging, and I'm trying to remember, there was unexpectedly I was almost blindsided by a sudden delve into theoretical biology, I suppose. I can't remember the expression that was used, but that's a whole new dimension, completely new to me. Peter, I'm going to now invite Yuval Lee and wait for your responses to both contributions. Is that's the way we've done it before? Is that the way you want to proceed now?
I think it's better that Juan.
Okay.
No,
yeah.
Talk and then we.
Okay. So
then I'll answer, and then we have an open discussion. I'll answer briefly.
Yeah. Okay. So now I'm going to invite Yuval Lee from the School of Law, Central South University in Changsha, to respond to Peter.
Okay, thanks, Joe. And first of all, thank you, Peter's sharing on your views. I would say that your text. Today I'm going to also to respond based on your text, and I would also start more focusing on the some of your ideas, but not all, because you know the views you shared with us is quite ranging and it's very broad. As you know that I am a lawyer, I'm kind of like specific, concrete, and more empirical. So for this reason, I would reflect. I would contribute some of my reflexive thinking based on your wrote some of the especially some of your the quotes from your text. And for other source, maybe we would leave for the further discussions, especially we have some audience and other group members today. Okay, basically, so I will summarize your text a little bit, and then I would comment on one of your, I would say, very prominent thinking toward how to answer the society and humanity on the threat to avoid misunderstanding. Okay, so your text, Peter's text, advocates for a profound rethinking of jurisprudence in light of the challenges posed by the advancement of digitalization and artificial intelligence. You might have noticed for recent years, my research focuses on artificial intelligence, especially the application of artificial intelligence techniques to solve the legal problem. So this also have prompts me to think about some of the concrete problems arising from this process. So so my remarks is also based on my research experience. Okay, yeah. So your text further suggests that these developments necessitate a fundamental re-evaluation of legal system and the concept of the human rights. Indeed, it's acknowledgeable that the traditional view of society shaped by human-centric perspectives must be reinterpreted under the lens of capital lessons, which acknowledges the intertwined effects of capitalism, technology, and environmental degradation. Moreover, it is admittable that the current political and legal structures, as you said, is not adequate to address the complexity in this context. So against this backdrop, I noticed that you proposed civil disobedience as a kind of like possible response to the perceived failure of political, legal, and the legal system. So what I am going to discuss a little bit further is the civil obedience, whether this is a kind of like a solution, proper solution to the problem, to answer the legal and political failure to address the complexity. And I also noticed that previously Mehmet, his response also referred to civil disobedience. So I would like to share a little bit of my thinking toward this. Civil disobedience as a form of a protest and resistance has historically been employed as a means to challenge existing laws and systems when they are perceived as unjust or inadequate. However, it remains questionable whether disobedience could be applicable and effective in the context of artificial intelligence-induced legal and political crisis. So, so my my claim to start with. It is important to recognize that artificial intelligence introduces some unique complexity to the legal and political sphere. Artificial intelligence systems can operate at unprecedented speeds and scales often beyond human comprehension, which may lead to legal disputes and governance issues that are really difficult to address through the traditional means. For instance, AI's potential to infringe on privacy rights, as you also mentioned, perpetrate bias, or even undermine a democratic process. All these pose significant ethical and legal dilemmas that traditional forms of civil disobedience may not be equipped to resolve effectively. Furthermore, the nature of civil disobedience as a solution is rooted in the ability to mobilize public support and pressure the authorities to enact change. So in the context of artificial intelligence, in my mind, this could involve public protest against the misuse of AI technologies or demanding stricter regulations and oversight mechanisms. However, the technical complexity of artificial intelligence systems might make it more challenging for the general public to fully understand the issues at hand. So which could limit the effectiveness of civil disobedience as a strategy. So in addition, I would say the international dimension of artificial intelligence development as another layer of complexity. As artificial intelligence technologies and their impacts transcend national borders, we have noticed that coordinated international efforts is necessary to address the legal and political challenges effectively. But, civil disobedience on a global scale might be challenging to organize and sustain. And it may not lead to uniform policy changes across different jurisdictions. So based on the aforementioned reasons, So I think while civil disobedience has traditionally been indeed a powerful tool for instigating changes, its applicability in the context of artificial intelligence and digitalization-induced crisis might not be as clear-cut. More probably, the response to artificial intelligence-induced crisis would require more nuanced and technical, I would say technical solutions on the other side that go beyond the scope of traditional civil disobedience. Engaging with the technical aspects of artificial intelligence and advocating for the development of ethical AI frameworks and the transparent algorithms and also the accountable AI governance structures, in my mind, might be more like constructive approaches. What's more, the unique characteristics of artificial intelligence and digitalization would necessitate a multifaceted approach that leverages the strengths of various stakeholders to address the legal, both the legal and political challenges posed by this transformative technology. So this would involve collaborations between not only lawyers, legal aspects, technologists, policymakers, and also as well the athletes to create a robust legal and ethical infrastructure that can keep pace with the AI advancements and also the digital tendency of digitalization. So this is what I have in mind, and my remarks on Peter's writing, but only from a very specific perspective.
That's great. Thank you so much. You are Lee from Central South University, the School of Law, for those comments. So what I'm proposing to do is to go back to Peter for his reaction to some of those comments, and then open, if we have time, to open the floor to other comments from other attendees. A very wide-ranging text that Mehmet and Juan commented on, very wide-ranging range of responses. So if Peter can manage to address all of these in a satisfactory fashion, then I think you will get Nobel Prizes in law, in artificial intelligence, in social science, if such categories existed, or we would have to invent them for you. So over to Peter. Thank you.
Well, in the meantime, I opened the artificial intelligence site, gave all this into it, and asked for an answer. So here you don't get this one, but my personal answer. I did not really propose we have civil disobedience as an alternative. But we have to observe that this happens, especially now in various countries, and that the problem there is, if you want to use this term, the challenge is that we have, on the one hand, these private interests of large enterprises, of energy enterprise corporations, private interests against something that is public, that is diffuse. And we have to think about ways of getting this in to the discussion, into the development of law, because I think actually this civil disobedience is not a solution, but it is an expression of something that shows a need to change the way of thinking, of having lawmakers in the governments thinking in abstract terms, but having difficulties, and I know this from my political praxis, having difficulties actually to know what is the concern of people. I know it from different areas, not from energy and artificial intelligence, but this is what happens in many cases. And I think this is as well something where lawyers in a narrow or in the professional understanding have difficulties, and there I would question if lawyers really tried, in the case of the search incidences, to get the social into the discussion. What they actually did, I think they tried to keep it out, focusing on special, very special legal norms which should not play a role. In strict legal terms, it is about copyright. What is the matter of copyright if people attack in an aggressive way the foundation of a society that is open, attacking it in an aggressive way in the interest of copyright, in the interest of personal, the right of persons, people to hide, to say, no, it hadn't been me. If they say so, then they have to say it publicly. This is a public issue. And this is my point, and this is where I think law, in many cases, thought too much about legal details instead of saying we have a political case. And this is as well where I think we need, and this is of course something that may be disputed, we need a political, socio-political understanding of what law is about, not individual cases of what this person does not, but what does it mean in terms of the political being. What does it mean? Then I come back to one of the old things, law, Anatole France. The majesty of law is equality, and there the beggar and the rich person is not allowed to sleep under the bridges. In legal terms, yes, that's right, that's correct. But what is the point if I forbid a rich person, and this happened in Germany, for instance, in terms of social law, social legislation, I will show you that it is possible to live on a minimum income. They do so for 1 month, the fridge is full, everything is there, that's no problem. If you have to live on a minimum income or under minimum income for a long time, this is a problem. And then you have to apply, I think, a different legislation, a different view of law. I'm saying Anthropocene, trying to link this to this point, is a matter of looking at human beings living in the society, and the society is living as part of nature. It's not linking, not making a link, a bridge between them, but it is about being in nature, being part of nature. And this is something that the Capitalocene actually forbids. And there we have the Anthropocene, the Capitalocene, and we have to rethink, okay, with that. Anthropocene in this understanding of making it open to understand ourselves as part, now you can come up with large terms of the universe, of nature, of everything. That was 42, the solution to everything. But to recognize this ambiguities as well, and to deal with them, instead of finding small, little, detailed provisions that avoid open conflict. And if we have open conflict, be it in political terms that foreigners are, that there's this hatred, that there is violence against foreigners, that there is violence against nature, then we have to think, I would suppose, rethink the Anthropocene. Not saying it doesn't matter what humans, or if human beings exist or not. That's another question. We leave this open for another debate. But to say, well, at least we have to think, can actually human beings sustain human life if they are staying outside of this universe? But
Okay, thank you, Peter, for those responses. What I'm going to propose to do now, thank you, Peter. Is throw the floor open. Let me just see if I can, if any of our, and let me just take this opportunity now that I've got the hang of seeing everybody on the phone. I can swipe across. My goodness, I've joined the 20th century in terms of technology. I've already said hello and then welcome to Phelim, and I also see Grace and Eugenia. And am I missing out on anybody? No. So I don't know if Grace or Phelim or Eugenia would like to make any comments or observations at this point. No pressure, by the way.
Hi, Joe and everyone. It's a great pleasure to join back to our discussion again. I think today's topic is very interesting, especially Peter's sharing is quite thought-provoking. I think he has covered quite a wide range of topics, including the relationship between law and politics, and with morality, with philosophy, and all kinds of things. But it extends from there and leads to much more thinking we could have. I think there are a few points I would like to briefly comment and also ask for your advice. Well, the first question is that when we consider how much of a role law could play, we have to come back to the central question of what Peter has mentioned, the limit of human rationality. So when we come to the point, we realize that first of all, we have a limit. We are not the highest intelligent beings of nature or the master of the world. So we are only part of nature, and we are trying to discover the way it should work right. But we make mistakes all the time. It's just due to our inherent nature of foolishness or maybe short-sightedness. It's the limit of our rationality. So with this problem in advance, how can we say that law could solve all problems? It's impossible. And law is never intended to solve all problems of the society as well. It just plays a role of, from different perspectives, it could be said to serve for the interests of the governors or the sovereign. But at the same time, it could be serving for the interests of people. It could be settling disputes, but it's never a solution to all problem. So we have to rethink about what is the boundaries of the role of a law could play. And especially when we notice the reality where nations are quite selfish as well. We are living in a very divided world, not an international community serving for everyone, but we're living in under every sovereign's power's governance, serving for the interests of its nation. So there would always be contradictions or disputes between nations. So that would lead to a problem of international justice, where international law could play a role. So it's also very complicated how international law and domestic law are interacting. So we see sometimes that international law is not binding, but it originates from ethical or moral values that are quite good, especially international human rights law. It's quite progressive, but very few nations are able to enforce those laws, those international values and standards. So we see the tension between the law of, lex ferenda and lex lata. It could be said the ideal law and the realistic law we have. So I think there would always be a problem that as long as humans survive, as long as we live, there would always be a problem. But because we have very limited rationality, but at the same time, we should struggle to make it a little bit better. So that's my brief comment, but I would like to hear more comments from you. Thank you.
Okay, thank you, Grace, for that. Does any of our other attendees wish to Phelim? You're muted. Yeah, you're muted.
Hear me now? Okay, sorry about that.
Yeah.
Yeah, look, very interesting issues raised. I mean, I suppose my view on law is that maybe I've got a cynical view of law. You know, I think that law is primarily created by those who govern in the interest of those who govern. And there may be some mediation in relation to people power, either powerful lobby groups or less powerful lobby groups that get together and become powerful because they get together, bringing about some sort of change, things like civil rights legislation, etc., which often results from grassroots pressure. So you've got law created on the one hand by the governors of society and to some extent by the pressures of society that exist within society, forcing change. Why I'm cynical is because I think that law is formulated to serve certain interests and weakened to serve certain interests. And the second thing is that whatever laws exist in a society or in the world doesn't necessarily mean that people abide by those laws. Laws require enforcement of some kind. Some laws are enforced universally. Some laws are enforced in certain situations against certain groups of people and not others. Also laws require some element of consensus or agreement with those laws. So if you're traveling through Cork, you'll see cyclists ignoring laws every day of the week, going through red lights, for example, going around corners without indicating. You'll see motorists breaking the law, breaking the speed limit, not indicating when they go around corners, whatever it might be. So there's certain laws which are enforced, certain laws that are enforced against certain sections of the society, depending on biases or prejudices against certain groups in society. A law will be used to cause problems for a certain individual who's not liked, say, by the police or by the state, or a certain group of people that are not liked by the state. And of course, we've got different laws in different countries. In Ireland, for example, women, if they choose to do so, can walk about the streets wearing headscarves, hijabs, without anybody, certainly without the security forces, the policing agencies, putting them in jail or causing them harassment. You can't do that in France. Different laws in different societies. And as for international law, well, we know if we look at the history of the development of international law, the role of America, for example, in the development of international human rights law. Eleanor Roosevelt, etc., have a dominant role, and how certainly initially the emphasis was on individual rights, not on group rights, not on social rights, not on economic rights. And it has only been later, with later developments, that you've seen the development of a range of conventions which have been aimed to try and rectify that by protecting groups and by promoting socio-economic rights. But even those later conventions have not had the power that the original individual rights mechanisms had. I'm thinking, for example, as well of the Council of Europe. Whenever the Council of Europe developed the European Convention on Human Rights, predominantly about individual rights. And it's only later that you see the development of socio-economic rights and not given the same status whatsoever. So politics is deeply involved in the development of international law. And as for international law, the enforceability of international law, we just got to look at what's happening in Gaza. Absolutely incredible what is happening there with the Western world, which is so proud of itself in promoting human rights, complicit in the deaths of men, women, and children. And nobody cares, or very few people care, in the higher echelons of government in the Western world. And I think that shows to me why I'm cynical of law. Law is something that has been developed over centuries, but does it serve the purposes of humanity, never mind nature? I would say no. It's like everything else. It's a constant struggle. We live in a society where, if you want justice, then you've got to fight for justice, and it's very, very difficult to achieve that against powerful forces in society, even at the individual level. I mean, I'm in a situation at the moment where I'm engaged in conflict with social services over my sister who's got a learning disability, and social services trying to evict her from her house, even though she's supposedly in both international law and domestic law has human rights. People decide otherwise in positions of power. So it's not just, when we talk about the governors, we're not just talking about the government or the top echelons of the police and services. We're also talking about those street level bureaucrats who have power themselves. Power is invested in a lot of different sectors of society, who can decide whether laws are obeyed or not, whether laws are enforced or not. Anyway, probably coming at this from an emotional perspective, so maybe I should shut up.
Oh, thank you. Thanks very much, Phelim, for that contribution. I'm sorry to hear about your sister. Hopefully that'll work out. And that's almost a contribution, an independent, freestanding contribution in itself. So maybe at one of our future HRUG Open Talks, Phelim, you might consider being the lead speaker on some of those topics. Peter, I'm going to go back to you. Some of those later contributions were as I say, kind of views and viewpoints and approaches in themselves, as opposed to perhaps something that you need to reply to. I don't know if there's anything you want to add to that.
Yeah, I'll start with the statement question regarding law law solves problems. In a way it does. At the same time, I'm wondering, does it solve problems? Does it define problems? Or, that would be my point, does it provide a framework within which problems are actually defined and solved? There is a tiny difference between the three approaches, but that we have a framework that allows us to define what is actually the problem. We have this in when it comes to issues like murder, manslaughter, and so on and so on. At the end of the day, one person is dead. Bad luck. But how do we define not the death, but how do we define the justification or not justification of this death? This has to be, there we need a framework. Law, I ask frequently my students, or say this stupid sentence, we have the solution, but we don't know what the question is. I think this, in a way, applies here as well. We can solve something with law. We have all the paragraphs in place, but we don't know really what the problem is. As I said, if somebody is sleeping under the bridges because this person is very rich, just for fun, it's a completely different story to the person who is sleeping there because he doesn't have any accommodation, cannot afford an accommodation. This is actually currently as well, I think, a problem if we deal with these orientations of, you said it rightly, Mehmet, they are not all fascists, but they are attacking foreigners. They are protecting this national framework as this belongs not to us, but this is we own this. And there is, of course, a problem we have that we have a different world, and we have had similar issues before with the different dimensions, but we are globalizing, we are internationalizing, where migration plays a different role, and we just have to face it. And not just looking at the law, what does the law say, and now we have the solution. We have to look, what does nationality in terms of the legal institution mean? I am citizen of. What does it mean? Is it just to have a passport from where, or is it more? Is it something different? So in this way, defining this, providing a framework for finding solutions, and then I would say, suffering from at least by disciplinary orientation or profession, I would not say it's a moral issue. We have different laws, as Herrmann said correctly, and we have, of course, something that is a different moral stance coming from there. But we should, I think, find a way to look at what is the meaning of the development stage of productive forces. How do we get to these different moralities, if we want? Is it just an idea, or is it emergent from the objective conditions for the development of stage of productive forces? And then, of course, productive development stage of productive forces means to consider power questions as well. And power question is, for me, not something where I say, yes, it's a moral thing. You have power, you may have power, you should have power, or you're not allowed. It's something where we have to look at what does this development of productive forces mean in terms of societal development, in terms of development of humankind. And there, Karl Marx said famously, I think something like capitalism was the most progressive form economic formation until, but for some stage it was a hugely progressive form of the economic formation, because it was developing from or against the feudal system. Now we have a different situation, that this capitalism is not progressive anymore, meaning that it hinders if you want, using this term, develops the elaboration or the development, the unfolding of morality. And this morality, I would still think it's important to link this to the objective conditions, to what we can do as human beings in this universe, but as well what we can do as collectivity, not as individuals. Facebook does a great job. Google, I'm impressed by what I see, what they can do. But it is not, or it is only in part, and definitely not controlled by those who are concerned. So that would be my comment.
Okay, thank you, Peter, for that. And just keeping an eye on the time, we're coming to the end of today's HRUG Open session hosted by the School of Law and Central South University, the Human Rights Centre, in fact. And just one final observation from me, Peter. You mentioned the level of reproductive forces, and obviously in terms of the relevant socioeconomic theory, that's some adaptation of Marxism. So it kind of surprised me in a standard Marxist framework, or possible Marxist framework, that when you mentioned the decentering of man in terms of astronomy, Copernicus and so on, and the decentering of man in evolutionary theory, Darwin, in terms of the origins of species, and the decentering of man in terms of the rationality, if you want to if you believe Freud, which I don't particularly, but nonetheless, theories of human irrationality. A fourth element that I might have expected is a characterization of Marxism, and I'm trying to think of the exact quote, but one of Marx's well-known quotes is that men make history, but they don't make history as they please. And a kind of an alternative version, I can't quite remember the source of this, is that the formulation that history happens behind the backs of people, and capitalism's law of motion, to use one formulation of that, and that perhaps links with or is a kind of a rebuttal in some way of Grace's point. Grace was talking about, if we talk about irrationality, then not a rebuttal, but the only, not irrationality or the potential irrationality of people as individuals or collectively isn't the only source of an irrational social order. It may also obviously be to do with irrational in some way socioeconomic systems, which have their own dynamic and independent and often very negative impacts. So, having outrageously abused the authority of the chair to make those closing comments, I want to thank everybody who attended today, all our attendees at this HRUG Open Talk. I want to thank our contributors. I want to thank Mehmet Okyayuz from the Middle East Technical University in Ankara. I want to thank Yua Lee from the School of Law, Central South University, Changsha, and of course I want to thank Peter Herrmann, currently living in a resident of I can't remember how to pronounce the village you live in, Peter, but in Denmark, let's say, and also a research fellow at the Human Rights Centre, Central South University, Changsha. And I want to thank our attendees as well, as already said that. And just to remind people that the text of Peter's the text on which Peter's presentation today was based is available on the HRUG website. So I'll wrap up. I'll say thanks again to everybody and see you next time. Thanks everybody for attending.
Well, thank you. And we can see each other as well on YouTube, where this will be published for the show. Thank you.
Okay. Thanks everybody.
Yes, thank you. Thank you.
Thank you, everyone. Thank you.
Good evening.